Probate process start to finish. My name is Wanda Rochelle, and I am a licensed realtor and probate specialist serving Georgia, Alabama, and Florida. Welcome to my channel. Today we are talking about the probate process from start to finish, and we're going to today specifically cover the steps to the probate process. I'm excited because I have my guest here. She's been on my channel before. We have Sonia H here. How are you doing today, Sonia?
I'm doing great. Thank you, Wanda. Once again, it's a pleasure to be here and give out as much as information we can.
Thank you. Awesome. So again, Sonia is formerly a probate clerk in Georgia, and so she is definitely a great person, a great resource to be able to share the steps to the probate process. So let's go ahead and get started. And so, of course, Sonia and I have already kind of gone over what the steps are, and we have step one as filing the petition. Let's talk about that.
Okay, yes. When it comes to filing a petition, you have to know which petition you're filing for because you don't want to pay for a petition that is wrong. And when it comes to the petition itself, you have to make sure it's completely complete and filled out correctly. Of course, we're human, we make mistakes. If there is a mistake, you do have the opportunity to fix it later on, which is by an amendment. An amendment does have a cost, but in the county where I was working at, it was only $15 and $2 per page. I think they changed the fact of charging $2 per page where I was at, but each county theirs. So please make sure if you do have to make an amendment, make sure how much you have to pay. But yes, as in for filing a petition, just make sure it's complete, make sure all signatures are there, make sure you have all the pages because you don't want any missing pages on the petition. Also, make sure that the petition itself is that the people are able to read it because you write it you can write it with your handwriting, but lots of people can't read other people's handwriting. So if you do have a computer at home, I do recommend to go on the online website and just complete it by with a keyboard and just type it. But it makes the process much more easier, and every spot is hit with like covered in the correct spellings of the names and the dates and the all the kind of information that you need on that petition. But just please make sure you can read it, make sure it's complete, and just make sure that you have signed each spot.
Okay, so let's make I like to make it like explain it as though we're talking to someone that's in kindergarten. So
Okay.
when they file the petition, do you have to go into the courthouse to file the petition, or can it be done online?
Okay, so some counties do have the option to do the online, but some counties don't because they are trying to go fully hybrid. That's how they call it. Okay, so yes, some counties have it, some counties don't. So if the county that you're in does have it, yes, you can do it online. But if the county that you live in or that you have to file in doesn't have that option, then you would have to go in the courthouse and pay the filing fees, file the petition, and you submit it. Or you can do it by mail. Only thing is that by mail, there was an inconvenience when it came to the Page County because, like I said, they kind of made it easier for the customer not to charge $2 per page. But I think they set up like a whole. They were working on it when I left, but they were working on just charging just one flat fee and not having to count $2 per page because that did make it hard for people who couldn't go in the office because they sent in the wrong fees.
Okay. All right. So when
Yes.
it comes to the petition, though, there are definitely multiple petitions depending on
Yes.
the person's circumstance. But once they figure out what petition they need, their first step is to file it. And like you said, make sure that that they can read your writing, make sure it's filled out completely. Okay, awesome. All right, what is the next step? Give notice.
Okay, give notice. All right, this one is if you have listed a number of heirs and some heirs are not in agreement with you filing this petition, you would have to give notice to each heir that doesn't agree and that does not acknowledge of what you're filing. So we do have an option to either serve them, we're giving them notice by mail, or we have an option if they live in the state to serve them with a sheriff. Of course, for each there is a fee. We're giving them notice to respond in a certain amount of time. If they don't respond, then it will continue forward. But if they do respond and they want to contest or they want to not agree, then that's when the judge kicks in, steps in, I would say. He would step in, and then there will be a hearing.
Okay.
But yes, that kind of notice. Now, do you have any other type of notice you would like to talk about?
What do you mean?
Because we give the heirs notice, we can also give the creditors notice,
Oh,
the debtors notice. Like there's different type of notices we can send out as the court. When it deals with creditors and all that stuff, we own cars, vehicles, credit cards, all that kind of stuff. We give them notice also by mail, and we can also do it by the newspaper, publication.
okay. All right. So I'm glad you said that, because when we say a notice, if the notice that goes to the heirs, what is an example of what that says? What
Okay.
does that look like?
So usually it's just an envelope. Inside the envelope is the packet. That packet includes the petition that the petitioner completed, an acknowledgement form, and a copy of the oath, because the petitioner has to be oath. They have to go under oath. So they receive everything that the petitioner filed, and
Mhm.
then they'll see, okay, because we can't just send them an acknowledgement and they'll be like, okay, so what is this acknowledgement for? We have to send them everything that the petitioner filed in order for them to understand, okay, this is what you need to sign. Either you sign it or you don't have to. And then if they sign it, they'll send it either back to the person that's filing or even back to the court. We include our address.
Okay. All right. So the notice is just notifying them that there is a petition.
Correct.
All right. And then when it comes to the creditors, it's the same thing. And I'm assuming that's a notice just to say, hey, just want to let you know there's some assets here in case you want to be paid. Okay.
Yes, that's all. And honestly, like I said, some people have the option to either make a deal, say that they own a credit card and it's for, let's say, $2,000, and it has gone to collection already. And so that collection is bought by a company who are the people that call you all the time, be like, we give you a deal. Either you pay us $1,200 or it'll go bad on your credit. Okay, so on the person's credit. So they have an option to give them this opportunity because it's being filed and it's being probated. It really helps a lot when they issue them, when they already are almost done with the whole process, and they issue them the letters of administration or testamentary, because then the creditor would be like, okay, so either they will forgive the debt or they will also want their monies. So it just all depends who you're dealing with. But when it comes to creditors, it helps a lot when you publicate it, because there's actually companies out there looking for people who looking for the people who have passed away and they own money. So that's what I'm saying. It's very important, if you read carefully on the petition, coming back to the filing again, when you file it, it's very important for you to read it, because there is an option there to publish or not to publish.
Okay, awesome. All right. So far the steps we've covered were to file the petition and to then give a notice to the heirs as well as the creditors. And
Yes.
the third step is to inventory the assets.
Okay, so there is a section on the petition again where you would list all the assets. If you don't know, there is an option there. If you don't know the exact value of each asset, it's okay. But usually the judge goes by the list of assets that you have written down, and depending if the judge requests a bond, that's what the amount that you wrote, that's the amount that he will go based on. For example, if you have a vehicle that is worth $7,000, there's assets of two bank accounts that each account has $5,000. He'll go by what you wrote, 7,000 plus the 5,000 plus the other 5,000. So if he feels like you need a bond of $20,000 or the amount of what you wrote, then that's what he's going to go by. But it's an option. There's a lot of people that don't know the value of their belongings. So it's okay if you put unknown. But yes, if you want to list all the assets, it does make it easier. It does make it easier. That way we'll know what you're dealing with.
Okay, so listing the assets also helps the judge determine if there is a bond, and if so, how much it
Yes.
will be for. Awesome.
Yes.
All right, so step number 4 is
Mhm.
handle the bills and any debts that the loved one may have had.
Okay. So a lot of people, when I spoke to them, they'd be like frustrated because the mortgage don't want to talk to them. The utility bills don't want to talk to them
Mhm,
because they're not the person that the bills were named, like they're not, the deceased is no longer here, and they don't want to deal with anybody. So it
mhm,
makes it hard and very frustrating for these people. So they're like, what do I do? Well, of course you have to file something with the court, but when it comes to all these creditors and all these utility companies and all these mortgage companies, you have to make sure you have to tell them, um, I'm working on it. I'm trying to get these letters that you're requesting, because the first thing that they will send, either by mail or they will tell you verbally over the phone, is I need to know if you are the person that is going to be in charge, and we need these letters of testimony. They don't use letters of administration, they usually use the verbiage letters of testimony, because they tend to think that people are always going to leave a will, but there's sudden deaths out there that you don't get the chance to do a will. So they send you a list, either again by email, by the mail, or they tell you verbally, we need letters of testimony in order to talk to you.
okay, all right,
So, yeah.
awesome. So when it comes to handling the bills and debts, just to
Uh-huh.
clarify what you said, um, the people should know that the companies may not be as welcoming to speak to them, and that they may want the letters. And I want to make sure I clarify the letters, because there's a letter of administration if there was no will, and then other testamentary letters are if
Yes.
the person did have a will. So it's
Yes.
important for, if you're watching, to know that the creditors may want to see that letter for you to be able to handle those debts.
Yes.
Awesome.
Yes. But when it comes, a lot of people make the mistake, and I would understand where this mistake is coming from, because in when you're in a situation that you're grieving, that you want to take care of everything, that you still have all this all on top of your head, and you want to make sure the bills are paid, you want to make sure you're not going to lose the home. So I understand, but they make a mistake that they continue paying the bills, they continue paying the mortgage, and they don't let them know that the owner of these bills, the owner of this mortgage, is no longer here, and they make a mistake and they continue paying them without letting them know. Usually companies are very good, by knowing that the person has passed away, because believe it or not, but there's it's amazing how they can track the person down. Like, you don't even have to let them know, and then you receive a letter in the mail saying, oh, we're sorry for your loss, this and this
Yeah,
and that.
yeah.
Yes, but I'm thinking it's because of our social security number, that's how you're being tracked down or something.
Mhm.
But it's just the mistake that the customers make, is that they continue paying without letting them know, this person has passed away. And some companies get upset. I've heard really reviews from people be like, the mortgage company was upset because my husband had been passed away 5 months and I'd never let them know that he had been passed away. So now they don't want to talk to me, you know? So I would recommend them to just be honest, let each and everyone know if you have to pay bills and stuff like that, because if not, it can be complicated on the person.
Awesome.
Yes.
So the last process is or the last step, I should say, is
Mhm.
to distribute the remaining assets. But because I'm a realtor, I want to talk about if the person has a house to sell, where is that done in this process? Probably at somewhere towards the beginning, once the person gets the letters, get the approval from the judge to sell the
Mhm.
home.
Yes, so you need an approver always. Like if you have filed something with the court, you need to have in hand those letters because that is granting you each and every power to do whatever you can with this property.
Right.
You need that.
And I know as a realtor, the title company or the closing attorney will not allow us to proceed with the sale of the home until we have those letters from the judge.
You see? So it's very important when it comes to that. Some people decide to sell, some people decide to keep the home and
Mhm.
just inherit to the next person, or they just decide to lease the home. And
Right.
of course, for any type of decision you make, you need those letters. We need to know that you're the person that is the person in charge of everything. But when it comes to the home itself, um, because a home can be valued lots of money. And so you just want to make sure that if you're dealing with a testamentary letter and you're the person in charge, but you still have to go by what but by what the will says, because
Mhm.
we've had a lot of complicated cases where there's this one person in charge, which is the person that the testator left in charge, but they failed to distribute all the assets between all the heirs. And that's when they come to the court, the person that has not received their part comes to the court and writes an affidavit and explains or writes say an objection to any, like they can write an objection and be like, I feel they can just simply write something briefly saying, I want a hearing because this person that has been left in charge did not give me my part, did not give me my funds, did not give me anything that was said on that will. So
Wow.
you can go back as a person that has not received and go back to the judge and persuade
Right.
him.
Right. So that's, I mean, we're talking about step 5 to make sure that those assets are distributed according to what the will says.
Yes,
Yes. Wow.
yes.
Wow.
Because if you don't distribute as the administrator or as the person in charge, is gonna get you down the road. Yes,
It's gonna get ugly.
yes, you don't want that because there's people that even hire attorneys because such and such person didn't give them their belongings.
Mm,
Mhm.
wow. Wow.
Yeah, and then it goes back to the court when it could have simply just been distributed between all of them and just each and one and everybody gets their part. Mhm.
Wow. Wow. Well, thank you for this information, Sonia.
Mhm.
Um, it's very valuable. If you're watching this video, please click like. Please share it with someone because people in the community need to know this information. Do you have anything else that you want to add, Sonia, about the
Um,
process?
no, not today. Okay, we're just gonna keep it all the information we gave out. Of course, you know, if anybody doesn't have a clue, again, I always refer them to get advice, legal advice out there. Again,
Absolutely.
I am not an attorney, but I always refer them to not to go and directly hire an attorney, but at least look up stuff, search for stuff, you know. But that's it. We're gonna on our next video explain more and more stuff because again, this is a lot. It's a very good topic to talk about.
Good. And I'm glad you said that because sometimes there are people that cannot afford an attorney.
Yes.
So if you're in a position where you can't, you want to definitely, like she said, do your research. Also, I did a video and I'll place a link to it in the description area on what you can do if you can't afford attorney, because there are people that are in that position. So thank you again for joining me today, Sonia. My name is Wanda Rochelle. Thank you for joining us again. I can't say that enough. We appreciate you. We pray that you have learned a lot here on today. If there's a topic that you feel like you would love more information on it, please put it in the description area and we'll do our best to give you that information. If you are in the process of wanting to buy, sell, or invest, please reach out to me. I do serve Georgia, Alabama, and Florida. And again, thank you for watching us.